If you've been in family court long enough, you know the feeling. You solve one problem, and an avalanche of identical white folders, enforcement motions, and legal bills immediately buries you again. This recurring nightmare is a structural phenomenon called litigation layaway. It happens when the design of your family court case quietly manufactures a recurring, uncancelable subscription to legal fees. You're usually faced with a choice: accept a fast, vague, vibe-based settlement that keeps the peace today, or endure the immediate friction of fighting for a rigid, highly technical order. The ongoing conflict you experience isn't the result of some cartoon villain master plan. It is a predictable design flaw in how standard legal documents are written. This chart shows the custody trap. Look at the two axes. On the bottom, we have the level of detail in an initial order, from vague to specific. On the side, we have future court costs and conflict. The initial level of detail you accept directly determines what you pay later. If you start down here in the bottom left quadrant, an order that is vague but currently has low conflict, it rarely stays there. Over time, that vague language drifts rapidly into the top left quadrant, compounding your costs with every new misunderstanding. Nice-sounding, flexible legal phrasing does not buy you peace. It acts as a deferred payment plan that guarantees you will be back in court fighting over what those words actually mean. We call this ambiguity farming. Lawyers often draft agreements using phrases like liberal phone contact or holidays shared fairly. These inputs make the initial settlement process move much faster. It's easy to see the appeal. It feels cooperative, minimizes early confrontation, and gets the painful divorce process finalized so you can move on with your life. Let's look at this comparison table to see how those clauses actually perform. On the left, you have standard language, like reasonable parenting time. On the right, a technical spec. Exchanges occur at 6 p.m. with a 15-minute late policy. The difference becomes obvious when the language is tested. If one parent ignores a request or weaponizes a delay, the standard language triggers a failure. There is no built-in instruction for what to do next. Because that vague language lacks a defined consequence for refusal, you are forced to ask a judge to act as the default referee. That requires filing an enforcement motion, which requires paying your lawyer. Flexibility in family law breeds ambiguity, and ambiguity breeds expensive conflict. The solution is forcing your legal agreements to act as rigid, technical specifications. You have to stop treating your parenting plan like a set of relationship guidelines. To do this, every single clause in your parenting plan must contain 4 mandatory elements. If one is missing, you are holding a future litigation coupon. The first 2 elements are the rule, what happens, like the holiday schedule, and the process, the exact steps of how it happens, like the parent starting their time picks at 6 p.m. Then you add the deadline, when responses must occur, such as a 72-hour notice. Finally, you need the failure mode. This dictates exactly what happens if someone refuses or ignores the rule, like automatically forfeiting that parenting time. This architecture eliminates he said, she said debates. It creates self-executing consequences that happen automatically, without requiring a judge's intervention. Achieving this level of detail requires a significantly higher upfront investment in legal fees, time, and emotional bandwidth during the drafting phase. It is exhausting work. You are intentionally trading the immediate discomfort of hyper-specific negotiations today for the long-term financial protection of a self-enforcing order tomorrow.
Even with a perfect order, day-to-day disagreements will still happen. The goal is managing them without immediately defaulting to a legal motion. You stop paying for fluff motions by building a mandatory 4-step conflict escalation process into your order. We call this the dispute ladder. The bottom steps act as a filter. You start with a rigid written notice, one sentence identifying the issue and a proposed solution. The other parent must reply using only structured response options: accept, counter, or deny. This forces calm, objective communication. If the issue persists, you escalate. Requiring a 30-minute neutral mediator step before anyone can file for court filters out minor grievances that aren't worth the legal fees. If you do end up in court, you attach this entire record. This protocol physically prevents impulsive legal filings. More importantly, it builds an undeniable paper trail showing exactly who is attempting to solve the problem and who is being unreasonable. The trade-off is that you delay immediate access to the judge for non-emergencies. It also requires you to maintain emotionless discipline every time you send a message. The dispute ladder flips the courtroom narrative from 2 fighting parents to one reasonable parent using a system while the other refuses it. There is one more major trap in case design: the compounding costs created by adding third-party professionals like evaluators, parenting coordinators, or guardians ad litem. To neutralize this financial risk, your appointment order must mandate strict scope controls. You have to clearly define what they do, establish hard reporting timelines, and set firm billing caps. These boundaries prevent mission creep. They stop professionals from spawning endless new compliance arguments or generating open-ended monthly invoices that drain your accounts. Implementing these limits is difficult. Court professionals at opposing counsel will actively resist surrendering their open-ended authority, and you will have to fight to keep the language tight. If you do not explicitly control the scope and billing of court professionals, you are buying an indefinite, uncancelable subscription to their disputes. The underlying mechanics of family court are the same for everyone, but applying these structural tools depends entirely on your specific resources and relationship dynamics. This decision matrix breaks down tools for 3 litigant types. For the high conflict target, your priority is eliminating ambiguity. You need 4-part clauses and strict communication formatting because every gray area will be weaponized. If you are the budget-conscious litigant, you simply cannot afford expensive arguments over minor schedule changes. Your focus needs to be on the dispute ladder and firm motion thresholds. To survive on a budget, you must enforce an internal checklist on your own attorney. Demand that they prove a motion has specific relief and material impact before you let them file it, stopping you from paying for fluff. Then there is the amicable beginner. You are currently negotiating an easy settlement, and you want to keep things friendly. Here's the reality check. You must treat this rigid drafting process like buying a fire extinguisher. You build these strict, highly specific rules right now while everyone gets along, with the hope that you never actually need to use them. Relying on good faith is an emotional hope. It is not a viable legal strategy. You can never control a difficult co-parent's behavior, but you have absolute power to engineer a case structure that stops rewarding that behavior with endless court dates.